Hello, my name is Courtney Pullman, and I'm a licensed marriage and family therapist practicing out of Wisconsin. Today, we're going to be talking about one of the most, for me, and sounds like from some of my colleagues, the most nerve-wracking experience ever is helping clients go through divorce, and especially with like the risk of being subpoenaed and asked to be an expert in child custody and mental health evaluations and those types of things. It can get really ugly with or without a therapist involved. And it's one of the more common reasons why therapists are called into court. So it's really important to go over so that people, new therapists especially, have an idea of what to expect and tips for getting subpoenaed. So first, we're going to be talking about the general divorce process. I practice out of Wisconsin, so some of the details might be more fitting for Wisconsin, but we're definitely going to be talking about uh, national law and national ethic concerns for marriage and family therapists across the nation. The next bit will be child custody, talking about what it is, why it's important, um, what how much court are really involved in that. Um, and then next will be considerations for evaluating child custody arrangements or the mental health of the caregiver. And that's where it really, as a therapist, it gets really difficult sometimes because divorcing parents or arranging child custody of parents who maybe never were married, they can get pretty nasty. So, what is a therapist's job in that regard, and how do you uphold what you're supposed to be as a therapist, and what's your job as a therapist when attorneys and other parents can be really pushy about what they want. Um, so next we'll be going over the AMFT Code of Ethics and what to consider there, and then tips for releasing information when you are subpoenaed. All right. So first, let's go over what happens with a divorce. Um, First, a spouse has to file a petition to begin the divorce process. Even if one spouse agrees to get divorced and the other one doesn't, which can be a familiar problem for some therapists, um, a divorce can still occur. That person can still be served papers. Even if both spouses agree that they need to get divorced, somebody has to petition for the divorce. In Wisconsin, like many other states across the nation, is a no fault state, and that means that you don't need to prove that you've been wronged in a divorce. There doesn't need to be abandonment or an affair or anything like that. In Wisconsin, you can get divorced based on irreconcilable differences or really anything. It's kind of at your own discretion. So after the divorce has been petitioned, there might be a temporary order. Typically, that's what occurs, and that's will be kind of an initial hearing that will be like, hey, this is what's going to happen through the course of the divorce, because the divorce process, depending on how well the spouses can agree or disagree, um, they need to know in the meantime what's going to happen. So temporary orders might discuss like child support, placement and custody of the children, who's going to live in the home. Um, and then the nice thing about a temporary order is that it's usually granted within a few days and it remains in effect till the final court hearing. Um, so and yeah, that sets the groundwork for the divorce. What happens in the temporary order doesn't necessarily mean that that's how the whole divorce is going to flesh out, but it's important for clients to get that temporary order in place so that they can understand what's going to happen through the process. Next, they need to have the process. The process begins, then there's a response, kind of, all right, so what do you want? What do I want? Kind of give and take type thing, petition and response. And then there's the negotiation. If the parties don't agree on all issues, they need to try to negotiate their differences. Courts at that time might schedule mediation. Um, Especially with child custody. In Wisconsin, the court does not want to get super involved if they don't have to. They would rather have it go to a mediator and have the mediator kind of help the parents agree on what's best for the child and then present the court with that agreement versus a guardian ad litem, and other like lawyer stuff involved with that. Um, and then there's there's the divorce trial. If there's not agreements, a lot of the times it can be resolved within a court commissioner. You have your paperwork, you've already agreed on this, or your attorneys have already agreed on it, and the divorce can be done fairly quickly. If not, it goes in front of a judge and it's decided at trial. Both parties will give testimony, sometimes multiple testimonies. Um, and then finally, there will be the order of dissolution, which ends the marriage, spells out how the property and debts are to be divided, custody, support, any other issues. When the parties negotiate their own resolution, they can draft their own order of dissolution, submit it to the court. If the court approves it, the court approves it, and then it is over. So very briefly, what is child custody? It's a term thrown around quite a bit in divorce proceedings, but child custody is essentially the right to be considered before making decisions for your child. Parents can be divorced, and in emergency decisions, the parent that is there gets to make that decision. If a child breaks its arm, you don't have to call the other parent and say, hey, is it okay if I bring him to the hospital? Child custody decisions are like, where should we put the kid in school? Um, like those kind of non-emergency issues. Where are they going to live? What those types of things. Versus like child placement, which seems to be a thing that I've noticed that parents confused with child custody. Having joint custody doesn't necessarily mean 50-50 even placement. So that's something with clients to really help them consider, that joint custody doesn't mean 50-50 placement. Joint custody just means making decisions with the child, for the child, with the parent. And courts typically, in Wisconsin anyway, they favor joint custody because that involves both parents. There's research that indicates that having both parents involved in the child's life is typically in the best interest of the child. In situations where joint custody is not deemed the best option for a child, that's where it can be really difficult for a marriage and family therapist. Sometimes parents might put their child in therapy just to have the therapist be the smoking gun of a custody hearing. They think that because they initiated the therapy, that the therapist has to agree with them and has to kind of take their side, which obviously, according to the Code of Ethics, we're not taking sides. We are going to be objective and non-biased at our best, typically. But for considerations for evaluating child custody arrangements and mental health of a caregiver, the number one thing is what is best for that child. And knowing that research typically wants both parents involved, that if both parents can co-parent, even if it's not identical type co-parenting, it's best to have both parents involved in the child's life in some way. And then research that looks at what is detrimental to a child. Is the one parent bad mouthing the other parent? Is one parent unstable? Is one parent violent? Is one parent abusive or neglectful or involved in drugs and those types of things? And those are things that you want to consider when discussing childcare arrangements and child custody problems. Um, and then knowing that a lot of it comes from essentially hearsay. You'll hear it from the child, or you'll hear it from the child's parent, or you hear it from the ex-spouse, what's happening in the home. And knowing that, well, really, as a therapist, we can only say what our client has told us, or what the child has told us. And that's a, those are the things to consider in those types of cases, and to understand that, you know, according to the code of ethics, we're not meant to make those kind of recommendations. So according to the MFT Code of Ethics 7.2, MFT's testimony in legal proceedings, uh, marriage and family therapists who provide expert or fact witness testimony in legal proceedings avoid misleading judgments, base conclusions and opinions on appropriate data, and avoid inaccuracy insofar as possible. When offering testimony as marriage and family therapy experts, they should strive to be accurate, objective, fair, and independent. And that can be very difficult in child custody hearings. And an important thing to remember is that a judge or an attorney can file for impeachment of what the family therapists their testimony, essentially, if they don't feel that the therapist is being fair and non-biased. In the Code of Ethics 7.7, the separation of custody evaluation from therapy, it states that marriage and family therapists avoid conflicts of interest in treating minors or adults involved in custody or visitation actions by not performing evaluations for custody, residence, or visitation of the minor. So that's really clear, right? That we're not supposed to be evaluating our clients in that regard. Marriage and family therapists who treat minors may provide the court or a mental health professional performing the evaluation with information about the minor, and recognizing that it's from the MFT's perspective as a treating MFT, so long as you maintain the release of information. So what that means is, again, that we're not supposed to be the evaluator and the therapist, and that's something that clients don't know, and that's something to be very upfront about from the very beginning. That, oh well, if you're looking for an evaluator, you need to be clear on what my role is here. Am I a therapist or am I an evaluator? Okay, so the big section is tips for handling a subpoena. First, what you want to do when you get that subpoena, which can be very, very nerve-wracking, is understanding what does the subpoena want from you. Sometimes it looks like they want you to show up and testify when really they just want documents. And also a thing to understand is, okay, is this a subpoena or is it court ordered? Or is it both? So if it's a court order, you turn over the information. You can turn over the information without obtaining your client's consent only if the subpoena you receive qualifies as a court order from a judge, which is rare. If you don't have the court order, you need to obtain your client's written consent or authorization. You can talk to your client's attorney, and you can ask them for help on how to respond to this subpoena. If the client is a child, you need a legal guardian or parent to give that written consent. If you don't have a court order and the client does not want to give you that authorization, you can contact the party requesting the information and try to resolve the issue. If that doesn't work, you can seek guidance from the judge. You can tell the requesting attorney that you can't release confidential information without the consent or authorization. You can claim client privilege, confidentiality. You can try to file a motion to quash the subpoena. And there are things to do also if you feel like the disclosure will harm your rapport, harm the client, or or a third party. And that's where client privilege comes into play to protect that rapport, and that, okay, I'm here, I'm complying with this court order, I'm complying with the subpoena, but I can't give information about my client without their written consent. And there are lots of other options from there. You can ask the court or attorneys or the judge what kind of information needs to be disclosed. The bottom line is that you can't just ignore it. You can't ignore a subpoena, even if it's not been signed by a judge, even if it's just the DA that's asking for it. You need to somehow comply with that subpoena. Again, even if it is just to show up and comply and say, sorry, client privilege, I don't have the written consent, and legally I can't give you information without my client's consent. So that's been my presentation about the general divorce process, child custody, considerations when evaluating child custody arrangements or mental health of a caregiver, the AMFT's Code of Ethics considerations, their input, and then tips for releasing information when subpoenaed. Thank you very much.